before we begin, we've forgotten to acknowledge the fact that Mr. Mungo has announced that he won't be continuing on in this. Did I miss that? We didn't acknowledge that. I'm terribly sorry. I know that you. I know that you announced.
I've got 8 months to go, Senator.
I know, but you announced it the day after the joint standing committee hearing, so we didn't get a chance to acknowledge it there. So I will acknowledge it here.
It was actually the Treasurer's announcement. I'm but a humble servant of the government.
Of course. But can I just say thank you very much for your service, continuing service until that date.
End of May
date?
Next year.
End of May.
That's
End of
right.
May. Thank you very much. I want to ask you about a couple of things. The first is something that you mentioned a little earlier, which was the need for regulatory reform or reform to the regulatory framework for managed investment schemes, which I know is something that there are some very passionate people around this table. The government announced that it was going to do a review into managed investment schemes and the regulatory framework back in October 2022. So that was its first budget. There was an announcement then. You did a submission to that review in 2023, September 2023. It was 50 pages long. It was pretty heavy reading, but really important reading. And there was a number of recommendations that you made in there. That review seems to have gone nowhere. What do you know about where the review into the regulatory framework for managed investment schemes is up to?
Well, we engage with Treasury continuously on a range of issues, including obviously this one. The government, we've been working with Treasury and government on a range of issues arising out of the most recent set of problems we've had with Shield and First Guardian. I think it's really a matter of a government as to where we go from here and the priority any law reform will get. I don't know whether any of my commissioners can add to that.
Well, in terms of
Alan? Yeah.
Excuse me, in terms of the specific question, my understanding is the review itself has been completed, but then any further action, such as release of a report or something like that, would then be a matter for the government.
So it's been completed by Treasury and given to government.
I'm not aware of whether or not it's been given to government.
Do you know, Minister, whether the review has been given to government?
I don't have anything in front of me that gives me the answer to that
question. Do you think, is there something that you can just type and just say, has it gone to government? Is it sitting in government or is it sitting in Treasury? Before we start pointing fingers.
I'm sure there's a team listening who'll let me know if there's an answer that I can give you, Senator.
All right, that would be very good. There was a number of recommendations that ASIC made in their submission. I'm wondering whether anybody at the table could tell me, had those recommendations been put into place, whether some aspects, I'm sure not all, of the First Guardian Shield disaster and Line 2 could have been avoided, or, if you would like to rephrase that, if those recommendations that you have made in your original submission from 2023 are put into place now, could we avoid a repeat of the First Guardian Shield disaster?
Well, I really don't want to speculate in the middle of this situation as to what a particular law reform would have achieved. But I think we can all agree that some of the anti-hawking provisions, had they been revised, some of, not all of, the misconduct that we think led to the current situation could have been avoided. But the ecosystem here is pretty complicated. As I think Deputy Chair Court mentioned very briefly earlier, our whole arrangements in Australia are very permissive around investment. And so a lot of we encourage people to invest and there's no restrictions on that investment, broadly speaking. So, and it's very easy to register a managed investment scheme. So I think the critical feature of the current situation is that all of these losses occurred within a regulated superannuation environment. So I think it sort of behoves us all to sort of step back and say, well, how do we think about reform or changes so that the sorts of losses we're seeing here can be avoided or certainly diminished. But as I said earlier, we're a risk-taking, investing nation. That's what being part of democratic capitalist economy is about, and there will always be losses. And so the critical question is if we want to reduce those losses, and then I think we do need to think about restricting, particularly retail investors, from being able to invest in anything, pretty much.
The anti-hawking issue, I think, is a really important one, because obviously that was a Hayne Royal Commission recommendation, and it was legislated, and clearly what we're seeing is people subverting that law or circumventing that law is probably a better way of looking at it. That's something that clearly ASIC had picked up on some time ago and notified government that this was occurring. When did you first tell government that you could see people trying to circumvent the anti-hawking provisions and that they needed to be stopped?
Whether Commissioner Kirkland can recall the sort of the policy history around that particular issue. As the Senate, as you've quite correctly noted, there was consideration given to this very topic coming out of the Royal Commission. Certain decisions were made at the time, and Parliament took a position. And we've been living with that position, I think, since October 2020.
And it was unanimous across the Parliament. Everybody wanted to get rid of hawking.
So I think circumstances have now arisen where I think we need to revisit that. From ASIC's perspective, I think we would be in favour of a more conservative position, and that could very well have had a beneficial impact on the situation we're in at the moment. So I do hasten to say that and again, I go back to some remarks that were made earlier, we're talking about a pot of money that's growing all the time. The bad actors are attracted to it. The lead generation part of this is significant, but not the only part of what went wrong here. Commissioner Kirkland, you want to add to that?
My understanding is that ASIC, I guess, raised issues around some limitations of the reform at the time that it was being considered. And then, as Deputy Chair Court mentioned earlier, we've been doing lots of work around this issue of lead generation over recent years, and we've continued to brief Treasury on the practices we've seen the potential harm to consumers and our concerns about those practices. And I think probably our thinking has broadened out to be not just about I guess the anti-hawking reforms, but just thinking more generally about that business model and practice of lead generation that's been mentioned earlier in this hearing, because it does involve businesses that are often they often purport to not require an Australian financial services licence. They design their practices in a way that is intended to support that assertion. And they're very clever at attracting consumers and luring them into conversations that encourage them to switch their super, and they're being funded by a range of the other entities in this complex web that we've talked about in relation to matters like Shield and First Guardian, and ultimately that money is often coming out of people's superannuation. So we think there is a case for really looking more broadly at those business models of lead generation, thinking about how best to disrupt them given the clear evidence of harm.
So I could not agree with you more. But I'm wondering, when you first raised this with government, did you raise it with Treasury? Did you raise it with ministers? Did you do it formally in writing? Did you just do it conversationally? Was it in a round table? How often and when have you raised this issue?
So as I mentioned earlier, my understanding is that the concerns were first raised at the time that the reforms were being framed and considered within Treasury in the aftermath of the Royal Commission. And then we have regular engagement with Treasury around all of the work that we're doing, and so the issues continued to come up from time to time in the period since. So
have you formally written to government, written to Treasury and said this is an area of reform and it's urgent?
In recent months, Treasury has invited our views on whether there are any regulatory gaps that might be addressed as a result of the matters that we've been discussing. And as part of in response to that request, we have said that we think there is benefit in looking at this issue of lead generation, considering whether there are any regulatory gaps there, right, and whether there might be some reforms that would appropriately address those gaps.
Okay, so let me be a little bit more clear, and you can take this on notice. But since this government was elected, how many times has ASIC raised the issue of the circumvention of the hawking provisions and the growing concern you have with lead generators? How many times have you raised that with the government, in writing or verbally or at a round table, and on what dates? If you could provide that in writing, that would be very helpful.
Yeah, given the breadth of the question, I would need to take it on
Yes,
notice.
of course.
But I would say it's really only in recent months that we've really heightened and clarified our concern around lead generation practices as a potential area where there's a regulatory gap.
Yeah, okay, thank you. I just want to ask, sorry.
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 I ask one question that's come to mind since we had our hearing recently. The sample of the generation of interest that was tabled on the day of the inquiry had an address that was domiciled in another jurisdiction, right? It was a UK address where the contact was coming from. Can I perhaps ask on notice what observations can we make and what further consideration needs to be taken about overseas interactions with what's happening here in Australia, because there is a limit to our sovereign capacity to manage these things. What needs to happen to interrupt that overseas domiciling to get around some of these laws?
I think that is probably something we need to take on notice, but I would say that in all of these investigations, there are plenty of players that are based on shore and they're keeping us very busy in the investigatory work. And so I think there are plenty of people that we have scope to investigate and take action against.
Sadly, yeah. Thank you.
I've got one more, just a little issue that I want to cover off on. Let me be very... after the joint committee met, my emails were bombarded with additional information, things that people wanted me to ask, and trying to weed my way through it has been extraordinary. But there was one thing that stuck in my mind that I wasn't quite that I wanted some clarification on. The company Keystone, which my understanding was the asset manager for Shield, is that right?
Excuse me, yes, Senator, the responsible entity
They're
for
the
Shield.
Yes, okay. And now, ASIC tried to put Keystone into liquidation back in September last year, but the courts didn't want you to do that or denied that, or what happened then in September last year, is that right?
No, I don't think that's
Okay.
quite right, Senator. I'm just trying to find...
That's all right. As I said, I'm pulling
chronology.
together
They're in
bits and
liquidation.
pieces of information from all sorts of emails. So if that's not
Indeed.
right...
Perhaps what I could tell you is, in relation to Keystone, commenced a formal investigation into Keystone November 23, interim stop orders made in February 24. We made our first application to freeze the assets of Keystone. In June 24, we sought orders to have receivers and managers appointed to the property of Keystone in August 24. We got orders made to remove the voluntary administrators Keystone had appointed and have them replaced with our selection of administrators in September 24, and creditors resolved to wind up Keystone Asset Management in December 2024.
I missed that. What was wrong with the original administrators?
Keystone, who was subject to our investigation,
Yeah.
sought to have their own administrators
Right.
appointed, and we had concerns about their objectivity and independence, and we sought to have them replaced. and
Okay,
we
so
were
the ones that you
successful.
replaced them with, are these the ones that are from a company called A&M? What are they? Does that sound right?
No, Deloitte are the
Deloitte.
administrators.
Okay.
There is a company called... There's a lot of acronyms in
Yes.
this investigation. There's a company called AWL or something to that effect, AML, that is one of the, I think, associated with one of the lead generator or financial advice businesses. Sorry, I'm being vague, Senator.
That's all right. I'm trying to find my way through this
Oh, sorry,
myself.
Senator.
And it's really hard.
Sorry. Forgive me, Commissioner O'Rourke's just helping me. Creditors resolved to wind up Keystone on 2 December 2024 and to appoint Jason Tracy and Glenn Konevsky of Deloitte, in brackets now A&M. as
A&M,
liquidators.
that's what I was trying to get to. Yeah,
Right.
that's exactly what I'm trying to get to. Okay, so my understanding is that the liquidator
Yes.
told the unit holders that they were in fact creditors, and that only creditors could then vote on whether to put Shield into liquidation. And that there was an alternative model that was proposed that said that rather than put it into liquidation, you could restructure it, and that way the unit holders would get potentially more money. It might take a bit longer, but they could get more money. but the liquidators wanted to melt it all down, and their model was entirely reliant on positive outcomes of certain litigation along the way through. But they used equity holders essentially as creditors. And then, once they were appointed liquidators and started the liquidation process, they turned around to the equity holders and said, oh, actually, you're not creditors, which means that you get further down the pecking order in the liquidation. So the people that were at the bottom of the pecking order of the liquidation voted for the liquidation because they were told they were going to be up higher in the pecking order. Is that right?
I would have to take that on notice, Senator. I recall there was a dispute at around the time that the Keystone liquidators wanted to take one particular approach. I don't know, Mr. Savone, if you're more across the details, and I'm doing what I should not do, which is speculating slightly. My recollection is that we were not happy with what was being proposed by those liquidators. We didn't think it was in the interests of the investors, who we've always had at the heart of our concerns, and that's the reason why we sought to have alternate and independent liquidators appointed. So there may be, it may be referring to that dispute, but I'm very happy to take it on notice, okay. Senator. It was, there's been a large number of windings up and different liquidators appointed across a number of these assets.
Yeah.
But Mr.
And Senator, happy to take it on notice and provide you with a more fulsome response. But just to make clear too, as in the position we took was by making submissions to the court and the judge was satisfied that liquidation was the appropriate course here. As we've heard from a number of investors that, you know, and this I think is being perpetuated by certain people with interests, that had administration been allowed to be carried out, this wouldn't have collapsed. Right. But ultimately there's an independent arbiter or umpire, the judge. The judge was convinced that liquidation was the appropriate outcome in this matter. So it's not something ASIC does unilaterally. Yeah. We need to go to court, make submissions, and the judge was satisfied that liquidation was the appropriate outcome in the circumstances of this matter.
Okay. Oh, I mean, I can only trust others' opinions that understand this matter more deeply than do I, but just let me be very clear. Is it appropriate for unit holders to be considered as creditors in a liquidation?
I just would have to take it on notice.
It would be it's surely unusual. They must be equity holders as opposed to creditors.
There are just so many legal technicalities around superannuation, their rights, unit holdings and the like. That's all. I just would be speculating here. But it's something we could find out very quickly. In fact, somebody may let us know as we're sitting here, Senator.
It just sounded, there was something there that didn't sit right. It did sound like that a lot of these unit holders had essentially been convinced that A, they were creditors, B, so then they voted for liquidation, but then C, got told that they were much further down the pecking order in that liquidation than they anticipated. Had they known that, they wouldn't have voted for liquidation in the first place. Okay. Anyway, I will leave it there. Thank you. Thank you.
Thank you, Senator.